Good afternoon, everyone, and it's nice to see you again and welcome back. Welcome to the Alternative Dispute Resolution Certification Working Group. And as a reminder, this meeting is being recorded. Angela, Angela, would you please take the roll?
Yes. Armstrong, Coulter,
Here.
Curtis is absent. Dinkin is absent. Dubois is absent. Ellis,
Here.
Dr. Getz,
Here.
Higuchi,
Here.
Hodgson,
Here.
Jones, Kelly,
Here.
Kopaken,
Here.
Cruz,
Here.
Lowe,
Here.
Judge Lucky, Pulafsky,
Here.
Judge Pichon,
Here.
Robertson,
Here.
Tuckman,
Here.
Welch,
Here.
Yamshon.
Here.
We have a quorum.
Thank you, Angela. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
For those participating by Zoom video, you have a function for virtually raising your hand, the hand icon, which should appear at the bottom center of your screen. If you wish to address the committee, please click on that hand icon right now. For those participating by phone, you may virtually raise your hand by pressing star and then number 9. Each person will have 3 minutes, and as soon as as soon as you start speaking, the timer will start and you will have a 10-second verbal warning. I do have one advanced sign up from Nolan Stein. Nolan, if you're here, please use the raise hand icon. Okay, I see you. Oops, he just disappeared. Nolan, your mic has been enabled.
Hi, it's Noah, Noah. Can you hear me?
Yes.
Okay, great. So the issue that I'd like to address specifically is that of the mediator requirement, the certification requirement that proposes that a qualifying mediation must be a minimum of 2 hours. And this is something that I have had numerous discussions. I should back up. I'm a mediator, and most of the mediations that I do are in the LA County courts through a DERPA agency. And there has been significant concern and support that by not allowing mediations that are less than 2 hours in length to be used as qualifying mediations, you effectively exclude an entire class of mediator from being certified. And those are primarily those such as myself who mostly are mediating in the court system. Not only is it exclusionary, but you're excluding people whose determination of effectiveness by the judges and by the court system itself is actually by the opposite criterion, which is that we mediate quickly. So most of our mediations are under 2 hours. And the judges want us to reach settlements as quickly as we possibly can, which we often do in either 20 minutes, 30 minutes, 40 minutes, or sometimes an hour. But that is one of the determinants of our effectiveness, that we're able to work quickly. And by excluding us from certification, you also have a negative impact on the mediator ecosystem itself. The courts rely on us, and we are going to want to use courtroom mediations in order to gain qualifications. So you also create a disincentive for us, the effective mediators, from mediating in court, aside from just being exclusionary overall. So it's both unfair and costly to the entire system. So what we're proposing is that the 2 hour minimum just be removed and the 12-hour total number of hours be kept. That way, we can, if it takes us 12, 13, because we're effective, if we're more effective, it just means that we'll gain more experience and we'll settle more cases for you. So, for that said, we propose just the removal of the 2 hour medium minimum for qualifying mediation in order to qualify mediators. Thank you.
Thank you very much, Mr. Stein, and I can assure you that your comments will be considered by the working group.
The next public commenter is Mr. Kai An. Kai, your mic has been enabled.
Good afternoon. My name is Kai An. Political power control State Bar of California, Chief Justice, and Attorney General not to investigate Sacramento DA office and SPD make up a story that fake killer Mr. Jung So Fong hit and run kill my father Woon Kong on. DA case number 99F08735. I went to governor's office in Sacramento, but governor's office doesn't take any action. How a state government allow political power to control the government, law enforcement, and justice system to commit obstruction of justice activity. Therefore, it needs all members of State Bar, Board of Trustees, and all committee members to speak out and notify California Senate and Assembly to look into the issue. Someone is trying to control State Bar to cover up a scandal. Thank you for all of your time.
Thank you very much, Mr. An. Angela, are there any other members of the public who wish to speak?
There are no more public comments, Judge Pichon.
Thank you. Now we'll move on to the approval of the February 10th, 2026 open session minutes. Are there any corrections or modifications to the open session minutes? If there are none, may I have a motion and a second?
So moved.
And that was by,
Daniel Yamshan.
thank you, Mr. Yamshan. And a second?
I'll
second.
Oh, okay. I think that was Mr. Pulaski. Made the second. Thank you. Angela, would you please call the roll?
Armstrong? Coulter?
Yes.
Curtis is absent. Dinkin is absent. Dubois is absent. Ellis?
Yes.
Dr. Getz? Higuchi?
Yes.
Hodgson?
Yes.
Jones? Kelly?
Yes.
Kopaken?
Yes.
Cruz?
Yes.
Thank you, Diana. Lowe?
Yes.
Judge Lucky? Kolevsky?
Yes.
Robertson?
Yes.
Tuckman?
Yes.
Welch?
Yes.
Yamshan?
Yes.
Judge Pichon?
Yes,
The minutes have been adopted.
thank you. Next, we'll move on to the chair's report. And I don't have a report per se, but as you are aware, the working group's preliminary report and recommendations were posted for an initial informal public comment period. And as promised, they have been presented to you. We had quite a number of participants and narrative comments, which staff will go over with you. They were organized with the use of an analytics tool called Microsoft Power BI. And this program will allow the working group, staff, and interested members of the public and ultimately the board to filter and view the comments. If you note from the executive summary that we received, we will discuss accessing the Power BI dashboard and how to use it, the available features of the platform, and filtering the available information. We also received letters and email comments suggesting new elements for the certification program that were not addressed in any of the appendices. As time permits, we will discuss as much as possible today. And if you are so inclined to vote on any new modified proposals, we'll do that also. The comments are all being carefully considered, all of them, and staff spent a lot of time working through them. So next we'll move on to the staff report. Mia and Alan, does the staff have anything to report?
Judge Pichon, we are going to defer our staff report until when we begin talking about the public comments. Thank you.
Okay, thank
Just if
you.
I can contradict Mia for just briefly, I just want to hope that everybody had a pleasant, healthy, and productive hiatus. Thank you to those of you who submitted comments and who were in touch with us in the meanwhile.
Yes, thank you. We did receive a number of comments from our own, and we appreciate that very much. We will devote the remainder of our time today discussing how to use the analytics tool, Power BI, and the return from the informal public comments. We do have other things to discuss, and I will come back and introduce them at that time. So at this time, I will turn over the use of the Power BI and also the informal public comments, and that will be with Mia Ellis and Alan Weiner.
Thank you, Judge Pichon. I'll lead off this section of the staff presentation by giving a little bit of background, just a refresher on the proposal, and also a little bit of background on the comment process and on the comments that we received. As you'll remember, the working group's tentative proposal was comprised of 13 appendices that were broken out by a different subject area and that you all approved distributing for informal public comment. All told, these 13 appendices contained about 200 different specific proposals or specific recommendations. Because of the complexity of the proposal and the number of comments that we anticipated, commenters were encouraged to use the thought exchange platform. You, as working group members, had some access to this beforehand. We did kind of might call it, well, it was more than a dry run when we were working on the tiers recommendations, the recommendations from the tiers subgroup. So you had a little bit of familiarity ahead of time. Commenters were encouraged to use the Thought Exchange platform for two primary reasons. We really wanted to have the comments focused in on these very specific 200 or so proposals. And the other was, given the number of specific proposals and the number of commenters anticipated, we wanted to have the tool to help staff in compiling the comments and putting them together for your consideration. The Thought Exchange platform was broken down into three separate, what they're called engagements, that grouped several of the appendices, each of them. And that was because there wasn't enough capacity in Thought Exchange to handle all of the 200 elements and all of the questions about them in one platform. So the commenters were asked to indicate or encouraged to indicate one of four positions on the proposals: either agree with the proposal if modified, disagree, or select no position. Additionally, there was a free text field where they were invited to submit narrative comments about the proposals. So if you take the five options, the four positions on the proposal, and the narrative, that's five options for each one of the 200 or so proposals, roughly 1,000 items that the commenters could comment on as part of the thought exchange. Something was wrong with my math there. 400 potential responses, or 500, I'm sorry, 5 potential responses per commenter and 200 recommendations. So yeah, that is 1,000 potential responses, which is quite an endeavor, especially when you think about the detail of the specific proposals, how much thought you all put into them, and how specific they were. Some commenters chose to submit their comments by letter or email, either in addition to or instead of through the Thought Exchange platform. There were 21 comments that were received by letters or email, and those were provided as one of the attachments to the staff memo that you received. Those letter comments were parsed by staff to put into the Power BI database along with the Thought Exchange comments, which allowed them to be sorted into the different categories, or sorted by the different 200 different questions, or the 13 appendices that are summarized in the first attachment to the staff memo. Overall, there were approximately 80 people who submitted comments either through the Thought Exchange platform or through individual letters that were parsed by comments. And we don't have an exact number right now because of unique commenters, because some people submitted essentially duplicate comments through Thought Exchange and through the letter process. But we're pretty sure that it's in the mid 80s. So the comments from the letters were added to the Thought Exchange comments and are all incorporated in the Power BI platform, which Mia is going to be explaining to you. They were also sorted by the specific appendix and question number in the first attachment to the staff memo that you received. There was some duplication of comments for a couple of reasons. First of all, some of the 200 proposals that you made and your tentative recommendations were very similar. So, for example, the training that was required for different tiers of certification, or the definitions of the training that was required, or the qualifying mediations and arbitrations. So some commenters understandably submitted the same comment that they had about a training requirement, or to Mr. Stein's point about the definition of qualifying mediation multiple times. So while the list of comments that you have is quite extensive and perhaps daunting, you will find that there are that there's overlap and duplication between some of the comments. In preparation for the upcoming meetings, staff is going to be trying to simplify the review of the comments for you a little bit more by categorizing them sort of by theme. So capturing, 6 people commented about, this concern, and putting those together to you in a format that might be simpler for you to review. I want to show you a brief summary. This is a chart that was just sent out this morning. It provides sort of an overall summary of the responses to each of the appendices. And if I can find my share button. So hopefully you're seeing a chart of commenters' positions by appendix. Can I get a thumbs up that that's displaying, or no? Yes, good, great. So as I mentioned, there were 13 appendices, lettered A through M. And there were 4 positions that commenters were asked to select on for each of the proposals within each appendix, including agree if modified, disagree, and no position. And then there was the unique comment field as well. So this chart summarizes for each appendix the number of people who agreed or who took any one of these appendices. Now, the reason that the numbers are as high as they are is because this doesn't reflect the overall position on the appendix, which wouldn't necessarily be helpful to you in reviewing the comments, but it looks overall at all of the proposals within a given appendix. And so within Appendix A, there were 105 people who indicated they agree, 42 agreed if modified, 70 disagreed, and 64 expressed that they had no comment. And then there were 21 unique narrative commenters within that specific appendix. So Mia is going to show you how you can drill down through the Power BI platform to get more information about the specific comments within an appendix and within the specific provisions of the appendix. So Mia, I'll hand off to you.
Thank you, Alan. So I'm going to share my screen. And can I get a thumbs up that you can see my screen? Thank you. Okay. So I'm going to clear all my filters. I was playing around with this morning. So this is the first page of the Power BI. And as you can see at the top of it, it has different filter options. List of the organizations, and this is a list of anyone who reported that they were affiliated with an organization or commenting on behalf of an organization. Also, as part of the comment, we were invited people to identify their role, if they were an arbitrator, mediator, facilitator, and then some others included as part of the other category. They included their role. We also then identified the appendix for which someone was commenting, appendices A through M. You also note the question ID option, and I'll get more of that later. And then specifically the question text. That's part of each proposal was included different areas for which a commenter could provide comments on. So as you can see here, this has a lot of numbers on it. And so I'm going to kind of drill down. And as Alan mentioned, we are still trying to ensure and validate the specific numbers. But in terms of our last count, we had approximately, it's showing here, 117 unique participants or responders as part of the thought exchange. If you go to the donut here, you're able to drill down specifically on the positions on each proposed appendix. And what I found the easiest to do is, for example, if you want to identify commenters on Appendix B, select Appendix B here from the drop down, and then it adjusts itself for positions on each proposed option. And as you can see here, take that away, it identifies for Appendix B, all of Appendix B, 24% identified agreed with the tentative recommendations, 18% or 124 agreed only if modified. Now, one thing with these numbers is that they represent duplicate responses. So there are a number of people who may have selected agree, and then they cut and pasted their positions throughout the thought exchange in the comment section. So, but let's drill down, for example, on Appendix B, those who agreed. And so all we have to do is click on this part of the donut and right click, and it shows up drill through comments. Can you see that? Can everyone
Yes.
see that? Okay. So I'm going to select that, and then it brings up all of the participants who commented on Appendix B and all of the questions. It lists all the questions here and their positions, and it should show everyone who agreed. And as you scroll down, some you'll see did not provide a comment, but you see their positions. And I think this was the one that there were no comments provided.
If I can just interrupt for a second. One of the things that sort of noticed is when people agreed with a specific recommendation, they tended to just check that they agreed. When people disagreed or agreed if modified, they were much more inclined to submit a comment explaining why they disagreed or how they thought it should be modified. So you'll find less comments with the positions that were in agreement. Mia, if you drill down into the disagree or agree if modified, I think they'll see that there's be a lot more comments there.
Mia, before you go on, there's a question from.
Oh, yes, please. Diana, I see
Just
now.
really quickly, is there a way for us to exclude the members of the working group when we look at this data?
I didn't understand the question, Diana. Could you restate it?
Yeah, is there a way to exclude the members of the working group when we review this data?
So in the Power BI, there is not
There's not.
currently a way to do that. If you look at the appendix or the attachment 1 to the memo, you'll see that a few of the working group members did comment, and you can see what their comments were, but you can't, the Power BI is not set up to exclude working group members from the analytics.
Okay, thanks.
The only drill down really is that I suppose you could do is really the role, but that doesn't really tell you who on the working group.
Can you filter by names, Mia, on it?
No, not because that would take me to, not on this page. You can't filter by name.
Okay.
And then even on this page, it doesn't allow you, don't think, to filter by name. There's no name. There's just roles. Okay. So let me go back to just show you also clicking on the disagree part of Appendix B. I'm going to drill down so we can see some of the comments related to Appendix B. And as you can see, this particular commenter gave their position on path 1, 2, and 3. And it's the same comment throughout, but they were able to submit their comment. And so you'll see a lot of duplicate comments, but and that is reflected in the number and why it's so high. Okay. And then you can also, I'm going to clear my filters here. Another option is to, if you wanted to identify a particular appendix, Appendix A, and then if you wanted to focus on, I want to know all the comments for someone who commented on path 1. And you can hit Control and select all of them, so you can select multiple options. And that gives you, again, here's the final donut. And if we go to those who disagreed, drill down, and you get some comments. The other option, I'm going to go back and clear my filters one more time, is the question ID. And the question ID, as part of the staff report, there was an attachment to, after all the responses, we provided a list of the questions and each question has an ID next to it, A1, A2, and they're really affiliated also with the question text. So with that question key, you can select the question ID. And again, question A1 for Appendix A. It already knows it's part of Appendix A. Again, you can drill down by selecting different parts of the donut. Any questions?
Thank you. Yes. Can anyone access this on the State Bar website or only the working group? And if it's only the working group, is there a link or a password we'll need?
No, it's public. It was posted with the staff report, which it was public. So they can, and the agenda was posted, and if they access the staff report, they have access to the Power BI. So it is public.
Okay, thank you.
Mhm. And they also would have access to the attachments, the PDF
Right.
spreadsheet as well. Yes, Ron?
The chart that you showed us that aggregated the whole thing, am I understanding correctly that if, for instance, a responder just disagreed with one of the proposals and agreed with all the rest of them, it would show a whole lot of agreement and a tiny bit of disagreement. And if everyone commented, just disagreed with a particular proposed rule and agreed with all the rest of them in an appendix, then wouldn't it make it look like pretty much everybody agreed on that appendix in the summary chart that we first got?
You want me to take that, Mia, or?
Yeah, I'm assuming you're talking about the chart that Alan showed?
Yes, ma'am.
Okay.
Yeah, so I think you correctly understand, Ron. If, let's say, Appendix A had 25 different proposals in it, if somebody agreed with one of them and disagreed with 24, that would show up in that fashion. And then that would be aggregated in the same manner with other people who agreed. That's why it becomes extremely important and helpful to drill down by the questions. So you can see, Mia, if you would show with, like, if you drill down into the first question in Appendix B, if you drill into what is, I guess, question B1, whatever it is, then the donut will show you what the comments were and what the agreement and disagreement was on that particular question. Does that
Um,
help?
I guess I'm trying to figure out where can we focus our attention, and the summary chart made it look like there was a whole lot of agreement. But as I'm trying to think of it logically, if I combine the agree only if modified and the disagree, a lot of those outweighed the agree, and they might only be on one or two questions. So in terms of where we focus our time, has staff done an analysis of where a whole lot of people either said, I disagree or I only agree if modified?
Yeah, so the chart that I showed earlier shows that on a very high level. So it shows it across all of the appendices. So encompassing all, let's say, 200 questions. Before the future meetings, I anticipate that we may prepare similar questions that look just at Appendix A and say on question 1 in Appendix A through question 20 on Appendix A, show the chart the levels of agreement, disagreement, agree if modified, in no position.
Thank you.
Would that accomplish what you're looking for, or is there something else we could provide that might better do that?
Well, from just speaking personally, if there's a whole lot of public comment on a particular proposed rule that's disagree or agree only if modified, that'd be very helpful for us to know. That's all I
Yeah,
was trying to get at.
sure.
And
And
the
so
summary chart didn't really do anything for me because they're all lumped together. I might agree with, a whole bunch of what's in Appendix A and disagree strongly, and so might every other commenter. But that summary chart didn't help me access where to look. That's
yes,
all I'm saying.
understood. And staff will be summarizing that and will be highlighting for working group members and the public the areas where there is extensive either disagreement or suggestions for modification, and suggesting that the working group focus on those areas in preparation for the future meetings. And Mia will be talking about the plan for the meetings going forward. So
Thank
that
you,
will.
sir.
Well, why don't I stay on that point, since that's one thing I wanted to make sure that we covered. As we outlined in the staff report, is today we thought we would focus on some of the new ideas that came out of the letters and emails that we received that were outside of thought exchange and also unrelated to a specific appendix or proposal as recommended by the working group. And so then for the next two meetings that we have scheduled, January 1st and June 1st and June 3rd, we would do exactly that, as Alan explained, that we would go through, provide us staff report for all of you with the highlighted themes and suggestions on proposed changes or recommendations and areas to focus for your discussion. And so, for example, for the first meeting, we thought we would start, rather than just going appendix by appendix, we would group together, for example, the first meeting, we would cover the mediators, qualifications as well, and the tiers. And then for next after that, we would, the arbitrators. And then the next after that, we would cover mediators and qualifications, tiers, and ethical standards and go from there. And so lumping those appendices together. And so to have more of an organized way of approaching them. So that's what we plan to do and provide all of you in advance of our June 1st and June 3rd meeting. You have a question, Ron?
Are you open to working group feedback about how we might like staff to analyze it and bring it back to us?
Sure. We one of the things we started doing it now, going through the comments. And we would like some feedback, and if you have any specific ideas on themes or areas or public comments that you would like to see addressed, we're welcome to receive that. And we hope to get that to you in advance so in advance of the June 1st meeting. But please, yes, if you have specific
Just speaking
ideas.
personally again, people who had the most disagreement with any given rule are where I'd like to see us focus some of our attention anyway. So that's all.
Yeah,
As
we
opposed
will.
to here's the mediation one, here's the arbitration
Yeah.
one, here's the rules. An emphasis on if we got a whole bunch of people who say that's a terrible idea or we don't like this definition at all. That's some of the focus I'd like. Thank you.
Yeah, if I can just jump in on that, yes, we will do that. Those will be areas that we will be highlighting, but we thought it would be best to proceed through an appendix and take all of the issues that are, let's say, controversial or where there are a lot of concerns about them from a particular appendix, rather than jumping around and saying, well, the highest number, we're on this, and we're going to do that, and then we're going to jump to this appendix, and then we're going to go back to that other appendix. So we're going to do what you suggested, but taking it one appendix at a time.
Okay. The other thing I just wanted to highlight here is, as we go through the tentative recommendations and the feedback from the thought exchange and the informal comments, we certainly encourage the members of the subgroups who are members of, for example, the arbitrator subgroup, mediator subgroup, since you have the most information on the reasons behind the recommendations, if you could be prepared to provide more context to and history to that recommendation, I think that would be helpful as well. I did want to also highlight, given that we have only 2 meetings scheduled, June 1st and June 3rd, we anticipate the need for scheduling more meetings, probably about 2 more meetings. And so we'll be sending around a poll for meetings in late June, early July. The poll will also cover times from 9 to 12 and 2 to 5. So we can possibly maximize the time we have together and to cover as much ground in those meetings, and possibly we may not need the 4th meeting. But I just want to let you know that that should be coming. Any questions on that? Okay. All right. I think that is all I have, Judge Pichon. I'm going to turn it over to you.
Okay. Mia and Alan, are you ready to move on to attachment 3 with the new ideas?
Yes.
Okay, good. So members of the working group will now move to attachment 3. There are 4, and it is a long way down, but Amia will and Alan will go over these with you. Attachment 3 contains new ideas, including ideas from letters and emails that we received. And those new comments include AI. And I just wanted to say this about AI, that they are for our consideration if you like, but I would like to note that there is legislation pending, and it might be a little premature for us to delve into that at this point. And if we do choose to continue something along the line of AI and to say something in our recommendations, it may be something like the general use of AI must comply with all applicable standards and rules, and leave it at that since there's legislation pending and there are changes being made every day. Some of the other new suggestions from the letters and emails that we received include private equity ownership and control, holding awards pending payment, courts and court volunteers not being required to be certified, and suggested statutory amendments. And again, I will turn this back over for discussion to Mia and Alan.
Thank
Mia,
you.
you're going to lead off with sort of a general overview, or do you want me to dive in and talk a little bit more, add to what Judge Pichon said about AI?
Why don't you go ahead, because I'm going to pull up my.
Yeah, so Appendix 3 begins with new suggestions that came out primarily out of the letters and the emails. Of note, one of those suggestions was in a letter from Senator Umberg, the working group who authored the legislation that became Section 6173. And throughout this process, the working group had questions that I think you were hoping Senator Umberg's office might respond to and provide some guidance along the way. And so here we do have some of Senator Umberg's thoughts, and they have been integrated, for example, with artificial intelligence. There were a couple other comments that related to artificial intelligence. So we've grouped those together, his suggestions, as well as others under the separate heading. And I would just say Judge Bichon alluded to pending legislation. So Senator Umberg indeed has Senate Bill 574, and the summary of that bill currently is this bill would prohibit an arbitrator from delegating any part of their decision-making process to any generative artificial intelligence tool. The bill would prohibit an arbitrator from relying on information generated by generative artificial intelligence outside the record without making appropriate disclosures to the parties beforehand. The bill would require an arbitrator to assume responsibility for all aspects of an award, regardless of any use of generative artificial intelligence tools to assist with the decision-making process. So as that might seem to address the comment that Senator Umberg submitted in his letter of comments, but of course the legislative session has not ended. Amendments are still being taken, and so as Judge Bichon indicated, it may be best for the working group to wait rather than making a recommendation now, even if is entirely in line with Senator Umberg's, with current language of his bill. If the bill language is changed, then there's the possibility of lack of alignment between the statute and the recommendations concerning the use of AI in the award. Also, the state bar has pending policies and rules regarding the use of AI. And Mia, do you want to touch on those?
Yeah, I will touch on that. There was another comment in addition to Senator Umberg's comment about AI. A commenter said that the bar should establish clear safe harbor standards in the use of AI in ADR. Just as background, the State Bar has it's called the Committee on Professional Responsibility and Conduct, COPRAC. And that committee addresses ethical issues involving licensees. And part of the committee's work includes studying and recommending changes to the rules of professional conduct. And they also draft advisory opinions on issues of professional ethics. And so just again, as in background, in 2023, the bar published was called the Practical Guidance on the Use of Generative Artificial Intelligence in the Practice of Law. And recently, the Supreme Court of California directed the State Bar to consider whether some of those principles provided in that practical guide should be incorporated in the California Rules of Professional Conduct. And so as part of that evaluation, the court directed the bar to consider incorporating any additional guidance that may be warranted. So COPRAC recommended updating the practical guide, and the Board of Trustees just last week approved publication of an updated practical guide on the use of generative artificial intelligence in the practice of law. And so COPRAC also proposed amendments to the comments to the rules of professional conduct to address the use of AI. And so those proposed amendments were posted for public comment, and they will go to the board at some point in the future. And then those proposed changes that were adopted by the board, if they're adopted, will ultimately require Supreme Court adoption. And so that's kind of the status of the rules of professional conduct as it relates to licensees specifically. We did want to open this up for discussion here. And as Judge Pichon and Alan indicated, there are a number, in addition to Senator Umberg's bill, other bills that are before the Senate in consideration, but I don't think this group has discussed this issue, and so we wanted to bring it to you.
Ms. Bruce?
Speaking for myself and some of the organizations that I serve on, I personally do not think that we should modify our group recommendations to deal with any of these AI issues, especially not Senator Umberg's proposal. I think if he wants to pass the law and he is trying to pass the law, that he should do it that way, and that us coming out and saying specific things about AI probably will not serve arbitrators or mediators well in the future, given all the changes that are going forward. And I know that a lot of people believe that Senator Umberg's bill goes too far when it comes to curtailing the use of AI in the ADR space. So I personally would be disinclined to add anything about AI in our recommendations.
Anyone else on that issue? Oh, yes, Mr. Pilevsky.
I tend to agree that we don't want to cross paths with the legislation. I just thought I would add a little bit of insight. I'm not a big AI user. I'm not an AI user or an expert in it. But for some reason, Senator Umberg's staff asked me to sit in on a meeting with a lot of the folks, lawyers for the most part, who were very much against his legislation. So just a couple of thoughts. One is right now the arbitration aspect is included with the same lawyer bill. I know that the courts are grappling with this and other people are developing better standards for lawyers. But I can tell you that a lot of the proposals were not very realistic about lawyers having to guarantee that there's no discrimination in the systems and things that they can't do. So I'm not sure where any of that's going to ultimately go. I do think it makes sense to wait to see what's going to come of it. And I also, in thinking about this whole project after reading the comments, there's so many different versions or varieties of arbitration and or mediation depending on the context. Family law mediation is different than business mediation. And same thing with arbitration. I have very strong personal feelings about arbitrators delegating the drafting of awards to AI in certain contexts, but I'm also a big proponent of autonomy. And I know that AAA is developing systems where people are agreeing for economy and other purposes to allow, knowingly to agree to allow AI to make those decisions, which to me, if it's a completely, truly knowing and voluntary, and we don't need to discuss whether adhesion contracts are, they're not. But I think that, there may be circumstances where if parties want to use a simplified AI program, that it would be a shame to sort of step in the middle of it if it was truly knowing and voluntary and those other systems were in place. All that said, I think confidentiality, which is already part of our mandate, does spill over into AI. The one thing I've learned in the seminars I go to is that you can't be putting case information, depositions, or anything that you would need to draft an award or do anything into an open system. And I think that we may be able to touch on it in terms of disclosure, but I think the confidentiality aspect of AI is something that we probably can still talk about in advance of other people working things out. And I think that there's a big distinction between research. You can't search Google now without using AI. So it's almost impossible to define what that is. But I do think that the drafting of the award is an area that we really might focus on. And in that meeting, when someone was opposing the legislation, it just occurred to me, I am really sarcastic, not only in life, but in cross examinations and other ways. And I asked the question, like, how does AI do with sarcasm or jokes? And I just read an article about that the other day, that they don't do very well with sarcasm or jokes. So I think that there's a lot that we don't need to get near, but I do think the drafting of an award, which would require you to input depositions, testimony, and a lot more, is something, if we're going to focus on AI, I would really limit that at this point to the confidentiality and the actual drafting of the award. That's all.
Thank you. Mr. Yamshan.
Thank you. I'm in agreement for a somewhat different reason. We are in the infancy of AI. And think about the internet in 1979 or 1980 and where we are today. In 2 years, we have no idea where this is going to go. Anthropic has already stated that they've developed an AI so advanced that it's too dangerous to release. So I think that anything we do today could be obsolete tomorrow. And so I'm in agreement with Cliff and Diana for perhaps a slightly different reason that what we do now will possibly not be too valid in the future if we decide to tackle it.
Oh, yes, Mr. Welch.
Yeah, no, I just think that that idea of the open source systems and the closed systems are ones of the AI environment that are going to be like when we're talking about language modeling and what systems they are, if they're internal and trying to having this idea of what it means to be a mediator, what it means to be confidential, and what it means to utilize tools that benefit and can work towards solutions versus what an individual and what people can have space to provide it's a larger discussion, but it is one to hone down that if we can help shape what we need as mediators to utilize these tools or for arbitrators to utilize these tools, that we could give examples of where that utilization can happen. And then hopefully we can shape the space where we need as individuals on what the tools can do for us and where our gaps are. Does it have to happen right now? Yes, there's going to be a lot of change, but I think we all need to be considering that for the future of how we want to have our systems work and the guardrails that are around them.
Thank you. Anyone else? Oh, yes, Mr. Kelly.
I'm hesitant to just let legislation be the thing that dictates in this area, because I think there's a whole lot of heavyweights lined up against Senator Umberg's efforts. If we decide to weigh into this, I think there's really simple, generic guidelines that already exist for an arbitrator consulting a human expert. There's already rules of court that say if I'm, as an arbitrator, going to consult an outside expert, I need to tell the parties who I consulted and what they said, so they can say that's not accurate. That's a simple concept, I think. And if I'm going to write an award based on information that I didn't get at the hearing, I need to tell people what I've heard and give them a chance to respond. I think those are really basic concepts. They already apply in the rules of court and in the Code of Civil Procedure to the use of human experts. And I think those give some basic standards if and when this group wants to weigh in some fashion. Thank you.
Thank you. Anyone else? All right, we almost got consensus on that. I mean, there is agreement from the 30,000-foot level, but there are nuances in how to address AI. So it looks like it won't fall off the list. So we'll keep it there for now. And then there were the other three areas that were mentioned. Mia, did you want to talk about those?
Sure. The other area was private equity ownership and control. This was a comment submitted by Senator Umberg. Private equity recommended tighter limits should be placed on ownership and control by private equity groups, as this has become an increasingly significant issue that may create conflicts with neutrality and fairness. As you recall, the working group proposed in its program administration guidelines for provider organizations that for general business requirements disclosure should include identification of equity owners. And so this was an ongoing duty for disclosure and to update the information. I'm recalling, and I think Alan specifically reminded me that there was some discussion about a specific percentage around, or possibly including a certain percentage around ownership, but we wanted to bring it back to the group to see if you wanted to further discuss the issue.
The recollection that I had was that the provider organization subgroup had made initially a recommendation that disclosures of equity ownership of more than a specified percent needed to be disclosed. And I think when that came to the working group for discussion, the working group said, wait, why should there be a limit? And I'm vaguely recalling maybe it was 30%. So why should there be a limit of 30%? If somebody has 5% is a 5% equity owner, that should also be disclosed. So that was the recollection that I had that Mia was alluded to. Maybe some of you share that recollection, or maybe I dreamt it.
Yes, Ms. Cruz?
I mean, from a practical standpoint, doing that to a provider places an incredibly onerous burden on them to kind of weed through corporate formalities and find out everybody behind the curtain. I think a lot of the providers would have a great difficulty getting that done, especially if there's no percentage linked to it. So I personally think that's another thing that is probably best for us not to make a recommendation on.
Thank you. Mr. Tuckman? I think you're on mute.
Sorry about that. I thought I'd unmuted myself. Senator Umberg's comment talks about placing tighter limits on ownership. And then goes on to also talk about significant issues regarding conflicts and neutrality and fairness. And I think we identified some of those issues. There may be some legitimate issues when you've got a party that has a connection to a provider through private equity ownership. But actually imposing limits, I think seems like not the type of thing that you would accomplish through certification standards. I'm not quite sure how you do that, actually. So, yeah, I'm also, I think, raising a concern, maybe an objection to moving forward with that suggestion.
Mr. Polewski?
I think that the organizations who are participating, I'm very proud of the work that we've done. And I think that the organizations that are on this call and in this part of group are not really necessarily the focus. That from what I can tell nationally, there are many investor groups starting alternative dispute resolution, like the New Era people who got into trouble by working with a law firm to draft. There's an organization in Chicago that are basically all owned by private equity type groups. So I think I don't want to get too focused on the good organizations who try to do the right thing. I do think that we have two different areas here in our existing rules. One is there needs to be some disclosure of all equity owners, if I read the rules properly, in the certification process. That if maybe I misread that. In the application, you have to identify the owners, equity owners. And in our Rule 6, we did say that there must be a disclosure to the parties if the owner of more than 25%. If someone owns more than 25%. And I was thinking this through to not get too far ahead of where the legislature really needs to get involved here, is that I think it would be good if there was a requirement to put on the website a link to the ownership information. Because if our D, 6D, where if there are disclosures made and a consumer or another party wants to say, sorry, I'm not comfortable, that's a pretty good protection against ownership or concern about ownership. I hope that stays in the proposal, but I think a little bit more disclosure can be accomplished by simply linking or making available access to who owns the firm. In not only private equity context, but I know arbitrators from the National Academy thought it was inappropriate for the arbitrators to have an interest in the firm itself and not just in their own practice. So I think disclosure is really helpful. So just a thought of linking and making available the actual ownership, coupled with the ability of parties to say, I'm not comfortable with that, is one simpler way than trying to limit, prohibit, or get too far ahead of the legislature.
Thank you. Anyone else? We do have, as Mr. Yamshan mentioned, some wording regarding that. Is that something you want to do a deeper dive into or leave it where we have it now?
Are you talking to me?
I'm talking to the entire group. But if you have an answer, I'd appreciate it.
Yeah, I think linking and making public the actual ownership is a very valuable thing to do. I think it's easy because the information will already be gathered. I mean, as I read the application rules, you have to disclose and update it, and I think that's very important information for everybody and provides some antiseptic approach. And as long as parties can object or to the provider, I think that goes a long way there.
All right. Well, we haven't heard from that many of the working group. So for now, we'll leave it on the list and then we can just decide later if that's something we want to do more work on. Ms. Ellis, Mia Ellis, what was the next one?
Yes, the next one is from Senator Umberg. This is holding awards pending payment. Specifically, it relates to the comment is the rule should address the practice of providers refusing to release finalized awards due to outstanding payment. While providers should clearly disclose their payment policies and may reasonably decline to proceed without payment once an award has been completed, it is unconscionable to withhold it. Organizations operating in the justice system, particularly those able to require retainers or deposits, should bear some ordinary risk of collection as other businesses do. The practice raises serious ethical concerns and undermines public trust, and it should be addressed as part of the rules or tiered structure to protect the public.
Any comments? Yes, Ms. Cruz?
Yet again, I just don't think this comment really goes to certification of anyone. And I do not think that it's a good idea for us to tell providers how to run their business or their collections and have them decertified, perhaps because of a payment issue. I think that it should be up to the provider to disclose their policies, and then the consumer can choose who they want to based on those policies.
Thank you. Mr. Palevsky?
Yeah, I wish consumers could choose the providers up front, but that's not really the case. I think this can be done as a tier. If we're talking about ethics rules, I don't think it needs to be a condition of certification. But if if we're talking about tiers of protection for the public, I think this could certainly be considered there. I think that there is a distinction once the award is done, and one party has control of the process and whether it gets released. Uh, so I would consider it as part of the tier thing. Along those lines, I was wondering when I actually went through and scrolled through all of the comments, and I've had this feeling all along that having three tiers is really problematic. It's probably one of the main reasons why my overall impression was this was a great piece of work, but it's too complicated. And I wonder whether there's a benefit to going back and asking the legislature to sort of rethink the notion of tiers. I think when it comes to ethics, it's really hard to say that there's tiers of ethics. Maybe two, but I think I've never been comfortable with the notion of tiers of ethical conduct. In terms of the specifics here, I think that I've had calls from people who are waiting for the award and the company doesn't want to pay. The whole notion of forcing the company to pay and become the sole determining factor of whether the arbitration proceeds or not is problematic. It was done as a response to mandatory arbitration, one of the many things that we've done to pervert the whole system uh, in order to allow that to go on. But I think that once an award is done and the case has been tried, you've had your hearing, and you're just simply saying, pay me, that collection, especially if the provider can take a deposit and does take deposits, uh, there's any number of ways to collect. And I think that there's a role for us to play in that.
Thank you. Mr. Kelly?
Although I highly respect my dear colleague, Mr. Polewski, I'm going to chime in firm agreement with the idea that Ms. Cruz has a handle on it. I don't think we should step into this area. I think it should be made clear, and organizations do make clear what their policy is. But if you have extended hearings and there's more that needs to be collected and one side will not pay, then parties have the option of fronting the money for the other party that hasn't paid and collecting it in the award, or going to court saying, give us a decision on this that they have to pay. And it's an important tool to get compensation for arbitrators, in my experience. So I'd like us not to try and change the rules we've come up with so far to address this subject. Thank you.
Thank you. Ms. Cruz?
Very briefly, I completely agree with Cliff about generally the tiers not being a good idea. I'm on the same page as you, my friend, there. Unfortunately, we do have the tiers at this juncture, and I think putting this in the third tier is going to run into exactly the same problem as we did with some of our third tier arbitrator and mediator issue. If you put this requirement in the third tier for providers, jams, for example, would not be a third tier like Uber Gold, provider, because they're not going to want to do this, which means you have like the disincentive and the confusion on the consumer basis, right? Of these like lower tier, frankly, like providers being in the third tier, and the big players who really like watch their ethics carefully not being in that tier. And I actually think that that would be counterproductive to consumer protection in the long run.
Thank you. Anyone else? So I think it's important for the group to decide whether or not this is something you do want to weigh into or not. Does anyone else have any feelings about pursuing this particular suggestion or comment? Is there anyone who would vote in favor of doing that? Yes, Mr. Pileski, yes. Anyone else? Would you feel offended if this was a comment that we did not pursue?
You're asking me again?
No, okay. Well, you know what? Comments can be raised again at any time, but at this time, it looks like there's no interest in pursuing that. But it is completely up to you. And I'm gonna, if we, let me ask, Mia and Jack, do we take a vote on it or just we just say this is something that it appears the consensus is that we not pursue?
Well, we don't need to take a vote on it. I mean, if I guess if the group wants to, and there's a motion to um, actually make a statement about it, can, or you can just not do it.
Okay, well, why don't we do this? If you decide, any of you, including Mr. Pulaski, decide at a later date before we complete all our considerations, if this is something you'd like to raise again, then we'll do that at that time. But for now, we'll work on the other comments. And I think there's one more, Ms. Mia Ellis, or are there two?
There's one more before there were some statutory amendments. There's is one parsed from the LA Superior Court. Courts and court volunteers not required to be certified to encourage volunteer service. The proposal should include that courts are not required to be certified providers, nor are court-connected volunteers required to be certified ADR practitioners.
If I could just
Yeah, go ahead, Alan.
speak to that real quickly. It's my thought about this is it's, by statute, it's a voluntary program. There's nothing in the tentative recommendations that were developed by the working group that would infer that anybody must become certified either as a provider organization or as a practitioner. And I think that could potentially be stated in the report to the Board of Trustees or something else that would constitute legislative history. I'd be a little bit concerned about carving out and saying, well, court volunteers don't need to be, but what other types of volunteers, might be included in the gap? So would that infer that some other type of practitioner would be required to? And so my suggestion would be that the working group handle this in a manner of legislative history rather than adopting a rule or a provision of the proposal that would carve out courts and court volunteers. But I don't think there's any question really that they're not required to.
Ms. Kopagan?
Yeah, I agree with you, Alan, that at this time it's not required, but I recall when we started this process, that you were quite clear in speaking to all of us in this group about how this was currently intended to be voluntary, but that at some point in future it might be not a voluntary, might be a mandatory scheme. So I think it would be important to recognize that any rulings we made might need to be adjusted if it became mandatory, because in that case, I think it would be very important to consider the court-connected programs in a lot of the things we're talking about. And, for example, as I'm sifting through the comments here, I see a lot of comments they weren't specifically on the court, the proposal that Ms. Hodgson and I made that were separate, but they filter throughout and they say court connected programs would be affected in this way or this way. And I see them throughout. So I think that's an important consideration that we might want to just, if we're including it as legislative history, if you will, for this, it should recognize that as well.
What does that mean? Does that mean include something new on it that we haven't included before?
Well, I think I've been quite clear that a lot of times that I think that we should, make some express statements about courts in a variety of aspects. But if we are opting and saying in this particular comment, it was raised as this is a voluntary certification, so certainly we don't need to carve courts out because nobody's required to become certified. That's absolutely a truism here, and I agree with that. I just think it's an issue that flows through many of the provisions that if we are considering that nobody, that the courts would be affected, the court programs, the day of court, the DARPA and others, the more extensive ones that we run in the federal program, are affected if folks are voluntarily certified. If it becomes mandatory, it would be much more impactful. And so just if we are opting not to address how this does affect court-connected mediation in a variety of aspects, then I would just suggest that I think it's important to include that this was deferred because this is a voluntary certification program. If and when it should become a mandatory certification, then that would need to be revisited, or at least potentially.
Okay, all right, thank you. Mr. Yamshan?
Thank you. I'm assuming that at some point there's going to be an introduction. The report that we will present to the State Bar will be something that they can approve or send back for amendments or modifications, but it would be a program that they can enact. And by that nature, it would have an introduction or a preamble, and we can make it clear in the introduction that this is a voluntary program, that people do not have to be certified to arbitrate or mediate in the state of California.
Okay, thank you. I think the legislation makes that pretty clear, but I understand including that in a preamble. Mr. Welch?
Yes, thank you. I would just note that for organizations or programs that accept a volunteer mediator that has the certification, by default, they then have to raise their standards to that volunteer mediator's requirement, be it what they're asking for, when it comes to just the information that they're going to be requesting or the policies that need to be built around it. So as soon as those individuals are brought into the programs, it will affect how those programs operate or accept or not accept those volunteers because of that. And I'm not saying that for my individual, but just generally that's a concern that those standards by default are going to be raised just the first time you have a volunteer certified mediator a part of your program.
All right, thank you. Ms. Cruz?
I think it's super important not to put this in the legislative history. I mean, it's part of the statute or in the introduction to the trustees. No, none of those places. Where I think it's the most important to put is on the State Bar website when this program is released. It should be one of the first things. Like we talked about these like important disclaimers on the top of State Bar information. That's like the first thing it should say. This is voluntary. It is not a State Bar requirement to be a mediator or an arbitrator. And right under that should go, this is not about quality because the statute says that too. This is just about certification. So I don't think we need it in any of those other places. I think we need it to the public. And by the public, I mean the people who are paying for these services and the people who are engaging in these services, like arbitrators and mediators.
Thank you. Ms. Ellis? Mia Ellis?
Yes, thank you, Judge Bichon. Just to that point, the program itself on the State Bar website could certainly say it's voluntary. Just so we're all on the same page, the State Bar, this program will be based in rules. And the current draft of the rules for the scope of the program specifically says it's a voluntary program to certify ADR provider organizations and practitioners. So we always refer people to the rules, and when we update things there, we're updating the rules and possibly the related policies. But I did want to make sure that you are all aware that it is currently in the rules, and it's the rules that will be going to the board.
Okay. Okay, that makes it clear. Mr. Weiner?
Unknown caller.
Thank you, Judge Bichon. I just wanted to add, as a reminder, that part of the working group's previous recommendation, or maybe it was in the charge, was that the work should be reviewed periodically. And I think, I'm not anticipating that there will be, that the program will become mandatory at any point in time. I was just saying that was a concern that people had raised, and I think certainly that would be an impetus for reassessment of the program. If it were to switch from becoming voluntary to becoming mandatory.
Okay, thank you. Ms. Kopagan? Your hand is still up. Okay. So it looks like from the discussions that this is one area where there is agreement The people who have spoken just want to make clear the voluntary nature of the legislation. So my question is this something we need to delve into anymore? If not, we'll take that one off the list also. Is there is there any objection to that? Okay, well, two things. Oh, yes, Mr. Weiner.
Not an objection, Judge Michon.
Okay.
If you were going to move on, I was just going to suggest this might be
You
a
can move on.
good time for a break,
Yes, it
perhaps.
is. Okay, so Ms. Cruz.
Can we revisit the first two and see if the group collectively wants to spend time on those two things? Like, I'm very excited to talk about Mr. Stein's amazing comment and all the other ones. If there is collective agreement that we should really dive into I think we should determine that today. Like, and if there's collective agreement that we do not want to dive into that, I think that it would be very helpful to our group to focus on other things.
Okay, yes, that's a great suggestion, and I would like to do that also, especially since we have net decided on two, and maybe the first two we didn't feel that we could actually go in that direction. So yes, let's do that. Mr. Weiner, you suggested a break, which is perfect timing because this is the time for the break. It is now 3:27. Why don't we break until 3:40?
Thank you.
All right, thank you.
Sure.
Thank you. All right, we're back in session, and Ms. Cruz asked that we revisit I believe it was the two items before, and one was the AI. So I'm going to ask Ms. Cruz for her reasoning.
Oh, I just think that it would be good to focus on all the comments that we got in our thought exchange. So if it's the group's consensus that we should add something on AI or discuss the issue further, fantastic. Let's add it to the list. But if those two issues aren't worth further consideration, I think we've got a lot to go on already. And so I think it'd be more efficient for us to focus on things that we know we want to talk on.
Anyone else? Anyone else have a strong desire to delve into AI or include a general statement about following the law as it is now, or just leave it alone?
Well, I'm not going to push it because I see I can count, but I think there's a couple of things like confidentiality and drafting the awards we could or should talk about, but we can move on if you don't want to do it.
Does anyone have an objection to not considering it as a new recommendation for us at this time? Okay, all right, then we'll take it off the list. And Ms. Ellis, if you could refresh my recollection, what was the second one?
It was the private equity. I believe,
Yes.
Ms. Cruz, are you referring to that?
Okay, yes. All right, Ms. Cruz, would you state your reasoning on that one?
It's just the same thing that I think that we've already addressed it in some of our rules. And I think that the suggestion that Senator Umberg's office makes is not about our certification goals or our working group. It goes beyond that. And I think that our time is spent better evaluating the other comments that people have made to our recommendations.
Would anyone like to be heard? Okay, and not hearing any objection to that, we will defer that. We will take it off the list for now. And if anyone would like to raise it at a later date, please feel free to do so. And Mia, Ellis, are those, do we have
There
it?
was
Go ahead.
the holding awards pending payment. That was the third.
We decided not to do that. What, is that right or? Okay. All right. Yes, that one
I
came
believe
up.
so.
Yeah. All right. So that takes care of attachment 3. Is that right, Ms. Ellis and Mr. Weiner?
So there were suggestions that that the working group, I guess, proposed statutory amendments, or there were suggestions that statutory amendments be made. And I think the same question is open to the working group about whether you want to take a position on recommending statutory changes, or at least, I guess, to discuss these suggestions for statutory changes so that they're top of mind for the working group. Mia,
Yes.
did you?
Mr. Weiner, did you finish?
Well, yes, I was just going to ask if Mia wanted to walk through those or wanted me to, or.
Or let me share my screen. This isn't a, let's see. Can you see my screen? Thank you.
Yes.
Okay. Enlarge it. This is one, yeah. The first one related to clarifying the scope of the State Bar Authority with respect to the statute and the creation of this program. Does the position is that the 6173 does not create a statewide licensing or ranking system for individual mediators unless and until the legislature separately authorizes one. And it says certification of firms should not be used to compel or indirectly require use of bar certified or tiered individual mediators. So that's again clarifying the scope. This is the scope, as I've already indicated, is outlined in the rules. I'm not sure what change to the actual statute is required here, but maybe it's along Cliff's statements earlier about tiers. No.
So I may be able to clarify that, but I also see Ms. Cruz has her hand up.
Oh, I'm sorry, Ms. Cruz.
I think in reading these, I think there are some helpful comments here. We do not have the power to amend this statute. I think many of us would be very happy if we did. And so I don't think it's a good use of our time to delve into an area that we don't have jurisdiction over. Perhaps we could send this to Senator Weiner's office and see if he's willing to make certain amendments. But other than that, I'm not sure how helpful it would be for us to go through these. One or two of the comments in here, like limiting certification to members of the state bar, I think we did grapple with that issue because we did go through, hey, how is this going to affect people who are non-barred, right? Neutrals. And we do have a system for that. And so I think the group did already consider some of these as well. But in terms of making proposals for statutory amendments, I don't think that'd be the best use of our time.
Thank you. Mr. Weiner?
Thank you. And thanks, Ms. Cruz. I'm flattered. I think you meant Senator Umberg, though, and not Senator Weiner.
I'm sending you my comments later, Senator Weiner.
And I think that may be a good suggestion. I also wanted to say that staff was really contemplating that we would begin digging into the specific comments that were made on the proposal at the June 1 and June 3 meetings. As we kind of discussed when we were giving sort of background about the plan for going forward, we want to provide the working group members with some more, information kind of highlighting what are sort of the major themes that came across in the comments and providing some background on sort of what the working group had discussed about it in the past or what the subgroups had discussed about it in the past. So my sense would be that we are not really as prepared as we would like to be, and we don't think the working group is as prepared as we would like you to be to start diving in the comments when we finish with this list. At least that's my sense.
Anyone else? So, oh yes, Ms. Jenna Ellis.
Thank you, Judge Pichon. I just wanted to say that I tend to agree with Ms. Cruz that it seems a little bit unnecessary, at least to go through these with the time that we have together now. And I hear Mr. Wiener's comment that there would be value in more time and further dissection of the comments received up until the June 1st meeting. But I suspect there must be a thing or two that we could discuss today. For example, Appendix M, I think garnered quite a few comments, including from various courts in the state. So I just wanted to mention that as well. Thank you.
All right, thank you. So, anyone else on the statutory changes? Okay, I do not see any other hands unless I'm missing some. All right, it looks like there's not much of an appetite to delve into a legislation at this time. So we will take that off our list for consideration now. And if, like I said, if anyone would like to pursue this later, please feel free to raise it whenever you think it's appropriate. All right, it looks like we've taken care of Appendix 3. And Mia and Alan, you can tell me if it's appropriate at this time to move on to our plan for the June 1 and June 3 meetings.
We can. It sounds like there is an interest in having a discussion substantively about some of the appendices. As you all know, the staff report didn't cover specifically those appendices. If we're starting with A, didn't cover anything yet. But if I would certainly defer to the group, Judge Pichon, if there's a desire for that discussion, we can. I could bring up the Power BI, or we can use the Excel spreadsheet to look through the comments, or however you would like to proceed.
All right, Ms. Cruz.
Just a suggestion for the group's consideration. Appendix M garnered a lot of negative feedback. The mediation confidentiality piece that I know Ron Kelly feels very strongly about also garnered a lot of negative feedback. Perhaps we can focus on areas where the group does feel prepared, maybe just 1, 2, or 3, to use our time effectively today. And then do the rest of it, on the next meeting, since I know the public's probably pretty excited for us to make our report to the state bar and get on with this in an efficient fashion.
All right. Thank you. Mr. Wiener?
Yeah. So my suggestion would be, if we're going to start jumping around in the proposal, I might suggest that we start by addressing Mr. Noah Stein's comment about the 2-hour requirement that he made at this meeting. And I'd like to provide some background on why the mediation subgroup came up with that recommendation and some of the other implications of it, if that's acceptable.
Is that fine with everyone? Okay, go ahead, Mr. Weiner.
Thank you. Mr. Stein's comment in effect was recommending that the definition of qualifying mediation that is incorporated into the requirements for being certified as either a tier 1, tier 2, or tier 3 mediator be revised. Mia, would it be possible for you to pull up Appendix B and particularly go to the last page of that has the definition of qualifying mediation?
I can,
Uh,
yeah.
Thank you so much. The mediator subgroup actually had fairly extensive conversations, and some of you here were on that subgroup, and invite you to join in the conversation. But basically, the subgroup decided that there should be a requirement of a minimum of 2 hours for mediation to count as a qualifying mediation towards the number of required mediations to be certified, either in track 1, track 2, or track 3. The working group discussed specifically the fact that that might have implications for mediators who primarily mediate in day of court mediation programs, small claims, civil harassment, and unlawful detainer in particular. And before I go into that in a little more detail, I want to start by thanking Mr. Stein for his comments, and also for taking a very proactive approach. Mr. Stein organized a town hall, if you will, under the auspices of the Southern California Mediation Association to bring his concern to other members of the community. And there were quite a few folks who attended that mediation. Mr. Stein encouraged them to consider submitting comments, sharing the view that he expressed in his comments today, that a 2-hour mediation shouldn't be required, and the impact that that would have on day of court mediators. So thank you, Mr. Stein, if you're still here, for bringing that to the working group's attention. Going back to the mediator subgroup in discussing this, well, first of all, let me say the proposal, the working group proposal, would not preclude mediators who do day of court mediations from becoming certified. Many of those mediators also mediate outside of day of court mediation programs. Many are volunteers with community mediation programs that do conduct mediations outside of the courthouse. Many, as I myself did, also have private mediation practices in addition to volunteering their in court programs. So many of these mediators would have other methods of meeting the requirement of, I believe it's 6 qualifying mediations of 2 hours or longer. The impact of the requirement, the 2-hour requirement, would really, I think, be limited to mediators who only do day of court mediations, and their valuable services to the courts in doing that is not to be discounted in any way at all. And as Mr. Stein pointed out, excuse me, their ability to resolve cases promptly in a short time while the court is hearing contested matters. Mediators often go out, in the hallway or into a conference room and try and help other parties resolve their disputes. And it's a very valuable service, again, not to be discounted in any way. The reality, though, is that at this point in time, the program contemplates only one certification for mediators. So there was discussion about whether there should be separate certifications for family mediators and for employment or other types of mediators. And the working group decided not to do that, at least in terms of the initial rollout of the certification program, but that might be considered by the state bar at some point in the future. So the relevant implication of that is that a mediator who was certified based only on conducting mediations in the courthouse that were less than 2 hours in length would not have engaged in many of the activities that the public would likely expect a certified mediator to have. So a day of court mediation program mediators are not involved in convening mediation. So the cases are convened for them by the court. They're in the courthouse, and the convening basically consists of, often the judge suggesting the parties go talk to the mediator. So in the private mediation context, as many of you know, there's a lot of work that goes on before you ever sit down at a conference table with the mediation participants. And the mediators who've only done a day of court mediations would not have that experience. And there are other facets of mediation, such as the ability to continue a mediation, to allow the parties to give it further thought, to do additional preparation and come back, that are fairly common in the private mediation context that don't occur, don't have the opportunity to occur in the day of court context. And so the view of the mediation subgroup, and I welcome others to speak to it, was that the experience for general certification as a mediator should include these other facets of conducting a mediation, as well as conducting lengthier mediations. Conducting 24 30-minute mediations doesn't quite entail some of the facets that conducting longer mediations might. And so that was the reason why, after a good bit of consideration, the mediator subgroup, and I see Ms. Coulter's hand, and she was on that subgroup, so I'm sure she'll speak to this, why they recommended and the working group adopted the 2-hour requirement for qualifying mediations. One other aspect of Mr. Stein's proposal that I wanted to comment on that raises some concerns is his proposal and that of many of the folks who adopted his ideas based on his presentation to the SCMA group involve accounting of the number of mediations. I'm not sure if the word success was used, or mediations that resulted in settlement. So I think it was a minimum of 12 mediations, at least 5 of which resulted in settlement or something like that. When I was working with the Judicial Council and the courts and court working groups, there was strong discouragement of using settlement rate as a criteria for being on court panels, because there was a concern that this might encourage mediators to push for a settlement rather than to fully respect the party's self-determination. And so that's a concern that I would raise about Mr. Stein's and some of his others who share his suggestion to that proposal, that this could result in, especially in a 30-minute or 60-minute time frame, could result in a mediator who wants to become certified, either pushing to get the parties to reach a settlement so it would count as a qualifying mediation, or perhaps ending the mediation sooner, because it didn't appear that it was going to result in a settlement, and they would perhaps move on to another that might. Not to disparage the mediators, but there's always the possibility of that type of incentive. I will say that there were a large number of comments about this 2 hour requirement. One of the things that I would like to do and would have liked to do and plan to do is pull those comments together for the working group to look at all of them. And, frankly, I would have preferred to do that before providing the explanation that I just had. But again, based on the desire to move forward with some discussion and the fact that Mr. Stein made his comment today, um, perhaps we'll come back and do that, at a later time. But that's all I would say at this point. Thank you.
Thank you.
And I see Ms. Coulter.
Ms. Coulter.
Thank you. Alan, thank you for that review of our discussions because it was so long ago, it was hard to remember. In my own conversations with Noah, the concern is that mediators want a path to certification. So not all DERPA mediators do private practice work, some only do DERPA. And under MC3, they were able to be certified. And so the concern is, I think, less about success rate. I think that they're open to conversations about how can we get certified. Their goal is they feel locked out. And I'm sorry if I'm saying this incorrectly, but they want a path to certification, and the path for certification doesn't exist for them. And so I just want to clarify that that is their concern.
Thank you. Mr. Welch?
Yes, I'll just speak to it because several are coming from Los Angeles County and doing work that I provide as an organization, right? And so I understand their concern, but it also is one that, and I was on the mediation, in our group there. And in our setting, we were still trying to figure out, okay, does voluntary count or not, right? We were trying to hash through a lot of things in that early iteration of our mediation program as we went through. And yes, I think the timing piece is like, would an hour and a half to an hour and 15 minutes or even an hour have a huge effect on these of individuals, what's taken or not? I absolutely agree with that. I also understand where the context of the 2 hours came in and continuing mediations and things that have time to that. So I understand all the parameters that are coming into what we're discussing, and also just thank you, Mr. Winder, for taking the time even to take out of this group the minutes that we did to discuss it, to address it, and try to get in front of it at this point. I think that will also go a long way of trying to find ways that we can just be mindful to those that are volunteering time in their community and creating a path for mediators that are non-attorney mediators and others to have those times and experience to be able to then qualify and somehow gain this certification so that they can move their professional careers along as well and still have that opportunity. And I think it's just really finding this balance there that we can provide that and give them some assurances that they won't be left at the table on the side of it, right? That they could actually be a part of it. So I think that's the primary that's coming in. But thank you all.
Thank you. Ms. Cruz?
I just wanted to second or maybe third Claudia and Noah's comments. One of the best mediators I have ever worked with was when I was serving on the court, and her name was Debbie, and I was presiding over the restraining order calendar as a commissioner, and she could settle like cases that I thought were completely unsettable in, 5 minutes. And I have no idea what sort of magic this lady was using, but it was truly a gift that she had. She was one of those mediators who did not do a private practice. Really, she did it for the love of volunteering and the love of the court. And I think Noah's comments are so important because what we have right now is kind of a one size fits all model that clearly does not fit one of the most important classes of mediators. And it is exceptionally important that they be certified, quote unquote, potentially for the consumer, because people who walk into court, especially for the first time in some of these calendars, like the UD calendars, the restraining order calendars, they may not want to go to the mediator, right? Like they're looking for every excuse not to settle their case. And it's an extra benefit to the court and to consumers and to the neutral to be able to say, hey, I'm certified, just give it a shot, and let me help you, or at least try to help you. I agree, Alan, with your comments on the settlement rate. I don't think that necessarily is a good thing. But I do think that Noah's proposal of, hey, just, 12 hours total as opposed to 6 times 2 makes a lot of sense. And in looking at the comments, and I do think we should take more time for Alan, you to look at them more, thoroughly, and other people, but there were a lot of comments on this from the public. So I do think that this is an area where we should very, very carefully consider his proposal, because leaving all these people out in the dark, like Claudia talked about, would be a very serious disservice to our courts and to the public, in my opinion. Thanks.
Thank you. Dr. Getz.
Uh, Echo the sentiments about court mediators. I was one. I supervised them. I worked with them. I trained them. I had ultimate respect for their position. I just, in the purpose of this, and I think it was stated, Ms. Coulter stated it correctly. MC3 found a way through a point system to get around this issue, and ultimately court mediators could be certified. One of the complexities I wanted to put on the table for the working group, that I don't think we can resolve today, is that if you go through all the comments, there's a fair amount of comments that say that the court systems and the court mediators should be exempted from all the requirements here under the certification program. So ultimately, we have to wrestle with, I think, we have a path. If we develop a path for certification for a court mediator and they're exempted, then in their systems exempted, then what purpose does a certification serve? We can't really appropriately follow up on it with a court mediator. So I think there's some conflicting things out there. We haven't gotten to that point yet, but I just wanted to put it on the table that it's maybe a more complex issue than just talking about hours or however we want to put it. Thank you.
Thank you. Ms. Kopakin.
Starting with the last point first that Dr. Getz just made, I also agree that that may be a more complicated issue, so I'm not going to wade into that other than to agree with him. I think that's more complicated. In terms of the timing, thank you, Mr. Weiner, for trying to recap what the minimum requirements group had. I'd have to look back at my notes. I was in that one, that subgroup, and we struggled with this greatly. Mr. Welch, Ms. Coulter, and I all have worked with community mediation, and I have, administered a community mediation program. I have worked in the day of court programs in a variety of contexts, both as a judge pro tem and also as a appointed neutral in those cases. And obviously, I run a federal court program, which our program is really different. So I want to differentiate. We're talking courts, but that is a little bit loosely being used here, and it may be important to differentiate. Going specifically to those short form mediations, we did struggle with whether or not those should be included. And I at least my recollection is that my position was that they should, because for all of the reasons others have lifted up. And I think those are really important, that they do tremendous work. Some of them are so much more skilled and efficient than people I see take a lot more time to do the same thing. On the other hand, there were some aspects of it that we did think, some other forms of engagement that they might not be involved in. I remembered a little differently than Mr. Weiner did, but that's neither here nor there, because I think we should consider the comments more fully. And I'm not sure I guess there was over a majority who decided that it needed to be the longer form, but there was certainly, I couldn't remember how I voted on that, to be perfectly honest, at the end of the day, because I think those short form mediations are really valuable as well. I guess I just want to really emphasize and underscore, I completely agree with Mr. Weiner on the settlement percentages. I think that would actually be counterproductive to, protection of consumer interests. And I also think that it's really important to keep that is our primary objective in mind here. So I completely agree with that. In terms of just differentiating between the time scales, many of the court programs, for example, the ones who appoint mediators for longer, there are some that appoint them for longer courses. And so it's, again, another complicating factor when we're trying to, use a one size fits all. So I think that is probably a further discussion for later, but thank you for refreshing us on this. And to Mr. Stein and all the other folks who are looking at those shorter form mediations, understand that we are very concerned with that. I think all of us share that those are really important programs, and I would welcome the opportunity for everybody to consider that issue again, some meaningful way.
Thank you. Mr. Yamshan.
You're on mute, Mr. Manchin.
Sorry. Thank you, Judge Pishan. I was on the arbitration subgroup, but I understand mediators often try to integrate the interests of the parties and generate alternatives. I'm wondering if it would not be too unreasonable, excuse me, to consider carving out a day of court mediator certification, which would not imply that they are capable of mediating the Camp David Accords, for example. The problem is, Ms. Kopeikin points out, is there's the short day of court mediations, there's early neutral evaluation, which will take place in court for an entire day often, and the settlement conference pro tems that a lot of counties have, where lawyers, mediators are appointed judge for a day and hold a settlement conference, also on the day of trial. So those kinds of differences may create some contradictions that would have to be resolved. But given the importance of this debate, I'm wondering if, with all the intelligence in this group, if perhaps we can find some alternatives to accommodate that need.
Thank you. And Mr. Weiner?
Yes, thank you all. I really appreciate everyone's thoughtfulness on this. And the point about volunteer day of court mediators wanting to be included and wanting to have a path to certification, I fully appreciate. And, to Mr. Yamshan's point just made, if there were an opportunity to have a separate certification for day of court mediators that would allow for certification that would be, categorized as a day of court certification, I would be very open to that type of a solution. My concern, though, is that we talk about the public protection and transparency and accountability, and I feel like it's very important that somebody who is shopping for a private mediator not place a certified mediator who has handled 2-hour and longer mediations on the same list, if you will, as a mediator who has only mediated in the day of court program. So I would certainly be open to discussing a separate path. I guess a problem that raises that Mr. Yamshan also raised is, well, there are all sorts of genre of mediators and places in which mediations are conducted and circumstances in which they're conducted, and would the working group and the state bar, ultimately the state bar board of trustees, be amenable to having one separate category for day of court program in courthouse program mediators, and not at the same time recognizing categories for other types of mediators.
Thank you. Mr. Kelly?
A whole lot of these are hard bargained compromises. What qualifies as a mediation training? What qualifies as an arbitration? For how long? There are a lot of compromises that the working group has come to agreement on and approved and put out for public comment that might merit the same kind of investigation and more discussion about should we have several kinds of qualifications for mediators, for instance, in family. small claims court, labor management, whatever. I think of this as opening a real big can of worms that would spread throughout what we've done so far. And I'll leave it at that. Thank you.
Thank you. Anyone else?
I see Ms. Robertson's hand.
Miss who?
Robertson?
Oh, Ms.
Maddie
Robertson.
Robertson.
Yes, please.
Thank you, Mia. Agree with a lot of the comments, so I'll try not to repeat. But I was also in that subgroup where we grappled with this, and definitely was one of the people who think that a shorter mediation, such as this day of court, can encompass a full mediation process. I've also overseen like court and community programs. My students in the mediation clinic do a full mediation process, like start to finish, attending to all the skills and pieces of it, and so that can be completed in less than 2 hours. Because that was part of our concern, is like people really showing and using the skills of a mediator, and that being a piece of it. And so just to put out there, I think that can work in less than 2 hours. But also to raise up something that hasn't come up, which is that people who are on a path to like starting their own practice are often doing these volunteer and court mediations as a way to gain experience and to get mediations under their belt. And so if if they're seeing these programs as no longer a path to that because these mediations they're doing won't count, then it could discourage people from joining these volunteer programs, which I would be concerned about, because not everyone is doing it just out of the goodness of their heart to help the community and provide these volunteer services. And so I wouldn't want to have that negative impact on these volunteer programs as well.
Thank you. And Mr. Weiner?
Yeah, sort of come back again. I just want to respond to the fresh point that Ms. Robertson raised, and I agree that many mediators do use it as a path to private practice, and many mediators also use serving on court panels as a path to private practice. And I guess the question that I would ask is, do those mediators need to become certified at that stage of their practice, or is it appropriate for them to get the experience and to do the 6 2-hour mediations in order to get certified? So
thank you. Ms. Kopeikin?
Yeah, just one final thought on that, which is that I think there are many people who do it solely for the volunteerism and to give back to the courts, whether it's the short form ones or the longer form ones like we do in our program. And there is a concern that I have, and that I think others have articulated to me, that if you exclude those folks from the certification program, that it gives at least a perception of a lower tier of service to those who can't afford private services. And that, I think, has a chilling effect and undermines the confidence in the program. So I think that's worth just considering when we're doing this. And I agree, we should not go back and revisit everything that's been done, but where there were significant amount of comments, it probably bears, considering. So I agree with you, Mr. Kelly, but this one might be an exception to that. I don't think we want to do everything wholesale. Thank you.
Thank you. Anyone else? All right, I'm going to look to Ms. Mia Ellis and Mr. Weiner. There were a lot of great discussions, and the importance of this can't be understated. So it's up to the group if that's something you now want to include in our recommendations or you do not. The request was to discuss this afternoon. Do you wish to take a position as a working group on it? Let me just hear from the group on that.
Excuse me, Judge. I don't know that we're ready. I think it's clear from the comments that we have opinions about it, but I don't know if we're ready to say this is our official position. Are you asking us to say this is our official position? Or are you asking if we're open to having further conversations so that we can determine if we have an official position?
I was basically asking, yes, if you wish to take a position. on this. It may require, as you say, further discussion, but is this something you wish to take a position on? Ms. Cruz?
I personally do not want to take a specific position today. That would be my vote. And I actually think going back to Jenna's comment, that Appendix M, right? There was a lot of negative feedback too about whether court programs should be just wholesale exempted. And if that's the case, I think we should tackle actually that issue first, because if that's the answer, right, then perhaps this is not as big of a concern for this 2 hour issue. So that's my thought.
Yes, thank you. I was not asking what position you want to take, but if it's something that you wish to discuss further to take a position. Mr. Weiner?
Yeah, I was just going to be a little bit transparent with where staff is and how we're going about our process in terms of digesting the comments and preparing to prepare them for you. So Mia and I have been going through the comments in in the order that we were anticipating the working group would be discussing them, and we are basically in the realm of the comments on the arbitrator and the mediator qualification requirements and tiers. That's sort of where we are. You've all seen that there are thousands of comments. I think it's close to 3,000 comments. And so we're working through those. I can tell you that my quick read, if you will. So we have not gotten to Appendix M and the court program issue that the working group spent so much time on. I can tell you that from a quick look, there's a lot of support for the proposal that was made by Ms. Hodgson and Ms. Kopeikin. However, I don't think that Mia and I are yet in a position to do justice to what we would like to contribute in terms of summarizing that for the working group and summarizing that alternatives and proposals. So, I would ask that the working group indulge us or accommodate us in letting us do our preparation for you and give you the tools that we think will help you make a decision. I do have an alternative proposal for where I think we might go from here, which is that we could go through and highlight for you some of the comments that we have seen frequently on the qualifications for arbitrators and the qualifications for mediators that we will be pulling together for you in a more cohesive way before the June 1st and June 3rd meetings.
Okay, thank you. All right, Mr. Kelly.
So I had mentioned earlier, and Ms. Cruz had mentioned earlier, an alternative, which was to try and prioritize the ones that had a whole lot of comments, like whether the court should be exempted or not, day of court mediators. Plainly, I have a lot of interest in the disclosure of mediation communications issue. So just as a personal point of request to the staff, I'm going to be out of town and out of electronic contact for the first 2 weeks of July. If you schedule a meeting to discuss mediation communications, I won't get to participate. So I'm interested in getting to some of the heavier issues in the next 2 meetings, as opposed to going through in the order that the appendices were provided. If that's something that the staff can do, or putting it off to the second half of July, that would work for me. Thank you.
Mr. Weiner and then Ms. Kopeikin.
Yes. So to Mr. Kelly's point, our staff had discussed with the chairs, what order to take the appendices in, and that we sort of agreed that it would be helpful to move through them in a progression rather than jumping all about. But staff and the chairs can certainly revisit it in light of the comments and see whether it might make sense to pull some out of order. I can tell you that what I anticipate in the memo is, to use your term, Mr. Kelly, I think we're going to be highlighting the heavy issues that have a lot of comment and a lot of disagreement. And we're not planning to summarize all of the issues that had maybe one or two comments that don't seem that critical. As Mia indicated, we're inviting you. We'll send you sort of a list of the topics that we've prioritized and invite you to add to that list either before or at the meeting. But the issues that we expect to bring to you are going to be to use your word, the heavy issues on which there was a lot of disagreement.
Thank you. Ms. Kopagan?
Well, first, I just want to thank you to Alan and Mia. That's a lot of comments, and I think that I welcome your further thoughts on Appendix M, and in particularly how it might relate to some of the other comments, which I haven't been quite as focused on. And I think it makes sense to table the comments about maybe the baseline criterion, that hour, the hours point. Maybe it does make sense to consider that all together. I don't know. I'll leave that to you to propose something. But thank you for doing it. And I agree that there are some really weighty issues. The confidentiality one, looking through the appendix, that is one of the ones that garnered the most comments. And I think it would be a disservice if Mr. Kelly was not here, since he has been deeply involved in that issue and I think was in contact with a lot of the people who were really, submitted things. And I would really, I think it does a disservice if you're not involved. So I would second that. Similarly, I'm going to be out for part of the end of June and the beginning of July, and I would very much like to be a participant in the portions that involve the the court programs. I think part of the issue we had in trying to address the issues with the complaints and how they overlaid with the courts was reflective of the fact that Ms. Hutchin and I were both unable to participate in the portion that addressed the original complaint procedures, and so those issues I was unavailable and she had a death in the family. And so those complaint procedures got enacted when neither one of us could have any input because we were not able to be at the meetings. And so those things came up much later in the process. And I think that did a disservice to it and it was frustrating to everybody. So I would advocate that we try and, make sure that we do pace that. So for what that's worth.
Thank you. Ms. Mia Ellis?
No, thank you, Judge Pichon. I just wanted to also offer that, as we go forward with votes, ideally, we would like votes on all appendix at the same time, as opposed to piecemealing parts of the appendix. For example, changing the definition of qualifying mediation, and then later changing the definition, path one. We would like ideally to have one vote on an entire appendix, because that is what is going to the board. That would be the vote on that aspect of the proposal. And then, for example, using Mr. Kelly's disclosure issue, that's one part of the rules. So there may be other parts of the rules that generated comments, and then the working group wants to change part of those. So ideally would like one vote on all of the rules and move those forward to the board. I just wanted to offer that as we go forward.
Thank you. Mr. Weiner?
Yeah, I just wanted to clarify something that Mia just said, which I think what she means is we're not looking for an up or down vote on the entire appendix as it's currently presented. So we're not, so as we did what we were having the previous meetings to develop the proposals, that, there may be discussion and there may be changes, to one provision or several provisions, but ultimately after those changes have been worked out, we would like to have the vote on the entire appendix. So it is going forward with the recommendation of the working group to the board. But there is room for discussion and changes of individual pieces within them.
All right. Well, on Appendix M, you've all given us the staff and the two chairs a lot of information to use to bring back to you, and we will do that. I'm going to ask Mia Ellis and Alan Weiner, are you ready to move on to the final discussion, which is about our plans for the June 1 and June 3 meetings?
Yes, sure. I can take a little that. Our plan, and I think as we just discussed, was at least for June 1st and June 3rd is to cover arbitrators and qualification and arbitrator tiers, and then mediator qualifications, tiers, and ethical standards. We may be able, I don't know the timing of it. I mean, certainly those are the top two that we've talked about, and then go from there to the providers and the provider tiers, and then ethical standards. And then the last would be the rules, which covers the complaint procedures as well as the Appendix M. So currently that is the order. I recognize we kind of revisited that order now. So if there is a desire, I suppose, to do it in a different way, if you could give us some direction and insight, that would be helpful.
Yeah,
I saw Mr. Weiner's hand first, and then Ms. Cruz.
Thanks. I'm sorry, I didn't use my electronic hand. I think that based on the input that we've gotten from the working group, it may be best for us to revise our plan. And if we can, we'll talk to the chairs about this afterwards, but possibly we can begin at the end with appendices L and M, which address the Rule 3.1226, which raises the confidentiality concerns that Mr. Kelly has talked about, and then go from there into M, which has the court proposals in it. So I'll go publicly on record as saying I'm willing to discuss doing that with the chairs, and it sounds like that would be responsive to what the priorities that we've heard about Appendix M and the confidentiality issue. And then I guess I would propose that we move forward with the order that Mia has suggested, where we go into the arbitrator qualifications and tiers, and then the mediator qualifications, tiers, and ethics, and then go to the provider organization provisions. We would have already done the rules by then.
Thank you.
So can I just,
I'm sorry,
is the request to segregate out the mediation or the disclosure issue from the rules, and then the other parts of the rules we're going to go back to at another time?
I'm suggesting we do them all next, if that's okay with you, Mia. And I'm sorry, we haven't obviously.
No, I would like to
compare. Yeah.
Handle one appendix at a time in full. If that's helpful. If everyone.
Thank you. Let's see, did I see Ms. Cruz first and then Ms. Copagan?
Yeah, I was just going to suggest, I mean, maybe we really should break off that confidentiality piece and the court piece separately from those two appendices, because there's such big issues. I hope that the burden won't be too much on the staff. I mean, looking at the comments quickly, they seemed overwhelming on both of them, right? Like there's one simple idea coming out of both of them.
Yeah, I think you'll see, I'm sorry if I can just respond. I think you'll see, Ms. Cruz, when we prepare the summary, I think you'll see that those are the two big issues in those two appendices, and that once they're resolved, the rest is pretty much low-hanging fruit. And so I think I don't think you'll be disappointed by.
That's fair, Alan. I just like Jill wanted Ron for the confidentiality piece. I really want Jill for the court piece
Understood.
because when she raised the issue, it was a huge aha moment for me that I had not appreciated, and I was so thankful and grateful for her and Sarah's comments, and I just really want the experts to be there for that piece.
All right, thank you. Ms. Copaken?
Yeah, I might be throwing another monkey wrench into this. I'm going to be out of the country from June 19th until July 8th. So I I agree with everything that Ms. Cruz just said and Mr. Kelly said about, having the people who are most deeply embedded in these issues available. So I hope that I will be able to be, and our process takes a long time, and it should, because these are important issues, but just recognizing how long the issues may take, I'm just not sure that we'll get to it in the first and the third. So yes.
I was just going to say, I think that we'll be able to, if you're both available on the first and the third, and Mr. Kelly is available, I think that the working group will be able to resolve Appendix L and M on on the first of those days, honestly.
All right, and Mr. Yemchang? You're on mute.
Hopefully we'll be able to get things done, even if we have to go overtime a little bit. A lot of us have incredibly crowded summer calendars. I have 7 weeks of arbitration coming up. Other people are going to be out of the country. I'm sure Cliff is busy too. So if we can get it done, even if we have to go an hour or 2 hours over, we committed ourselves to be here and work together. And or start early. I'm certainly willing to do it.
Thank you. Anyone else? Okay, I'm going to turn it back over to Mia Ellis and Alan Weiner.
How are you, Mia?
Okay. Any other comments or I do see
Mr.
Mr.
Pilevsky.
I would love a head start if we could on the confidentiality part. And I was just wondering, not to get into a debate, if Ron and the other confidentiality forward folks have a solution or a proposed solution that we might just be able to start thinking about to the conflict.
Mr. Pilevsky, I think staff has a proposed solution.
Okay.
That we think will satisfy the concerns that have been raised by Mr. Kelly and the confidentiality people. So and that will be included in the memo that will go out before the June 1 and June 3 meetings. Just to confirm, Mr. Kelly, were you available on those dates, June 1 and June 3?
Yes, sir, I certainly am, and I very much appreciate the courtesy of the working group to try and take the court issue and the confidentiality issue in those two meetings.
And Ms. Kopeikin and Ms. Hodgson, I think you had both indicated, or Ms. Kopeikin, you're available on June 1st and June 3rd. And Ms. Hodgson, are you available on those dates?
Yes, I'm available on those dates. I did want to mention, since we're sharing our travel schedules, that I will be out the end of July. So I appreciate, again, the courtesy of the working group moving these agenda items up so that we can all be present and participate.
Okay.
So with the chair's consent, I think we'll reorder the schedule we had discussed before to put Appendix L and M at the top of the list.
That's fine with me.
Thank you.
All right. So Ms. Mia Ellis just went over what we'd like to discuss in our future meetings. We've made some changes today, which we will go with. Is there anything else that we would like to discuss today?
Can I?
Yes, Ms. Mia Ellis.
I do, but I see also Mr. Kelly's hand, please.
All right, Mr. Kelly.
Just a quick question. I noticed that one of the comments from Senator Umberg was, I intended this legislation to apply to all neutrals. And if I understand it right, staff has decided to do just mediators and arbitrators first. But the legislation pretty clearly says all neutrals, non-judicial neutrals. I'd be interested in whether or not staff and the chairs are thinking that this same working group, and I'm glad that well, I don't see Erica anymore. Oh yeah, you're there. Is it this same working group that would try and take on early neutral evaluators and referees and the other kinds of neutrals where the ethical standards are not specified in the legislation? Just to sort of plan my next year, I'd be interested in that question now or sometime in the near future. Thank you.
All right. I don't know if Ms. Doherty would like to respond to that. I see you've taken yourself
Well,
off.
go ahead, Judge Pichon, go ahead.
I was going to say, you've made it known, Mr. Kelly, how you feel about that, and I believe that's something that we should discuss first and then give you a response. But if Ms. Doherty has something um, to tell you, then please, Ms. Doherty.
No, I think that's right. And I think additionally in consultation with Senator Umberg's office and others as well I think there's a little bit of a balance of getting something going in this space as well as addressing the many, the variety. We're seeing these struggles through this conversation as well, right? That the one size fits all approach is incredibly challenging. And to add more different types of ADR providers and practitioners into the certification process, I think may expand beyond the scope of maybe what some people on this working group, perhaps not all, are willing to devote their time to in this iteration at least. But more to come.
So, Mr. Kelly, it's very fair to raise that. Allow us to discuss it and get back to you.
Thank you very much. I was just interested in where we think this might go over the next year or two and whether you're, and I don't need to know now, but are you intending to constitute another working group and we're all done, or try and keep this same one together to address other kinds of neutrals? And I don't need an answer now. Thank you.
All right. Thank you. All right. Is there anything else that you would like to discuss?
If I may, Judge Pichon, just I've heard many people mention in terms of your calendars that you have limited availability for, sounds like a lot of days in late June, mid-July. One of the things that I discussed with the chairs and Mr. Weiner is, and I mentioned earlier, is the possibility of adding 9 to 12 as a time frame to meet. Historically, the group has met 2 to 5. And so that time frame will also be on the agenda, excuse me, the poll. But I wanted to also gauge interest on possibly all day meetings for the working group. I see some facial reactions, but I just wanted to throw that out there. If we took a poll and people were available for all day, if people would be amenable to that.
Just let the old folks take a few breaks here and there.
Okay.
Yeah, for what it's worth, if it ensured more attendance, Mia, I think it'd be a great idea, right? Personally, even though that's a long period for us to block out, if we can get everybody there and then instead of losing people, I'd love to hear as many people's feedback as possible.
Yeah. Sarah?
If we were to do an all day, would it be we can come and go as we're able? Because I will tell you the next day that I have no meetings scheduled is in December.
Okay. Well, we would need to maintain a quorum for business purposes to transact business. So I suppose we could certainly have blocked out times and just ensure that that happens. But I would have to be mindful that we maintain a quorum. Mr. Kelly?
Just for the group's consideration, if we did an all day, if we had a 2 hour break in the middle of the day, like 9 to 12 and then 12 to 2, we could do a lot of business in that 2 hour break, or take a nap if we're geezers. I'll just toss that out for your thought. Thank you.
All right. Well, we'll send the poll with those timeframes, and then we can see what the results yield. Thank you,
Okay.
Judge Bichon.
All right, that sounds good. So, Ms. Mia Ellis and Mr. Alan Weiner, if there is not anything else that you would like to discuss, or that anyone else would like to discuss, then I will adjourn the meeting. Thank you so much. This was a wonderful meeting. Everybody had so much to contribute. I know we still have a long ways to go, but looks like we're going to get there and get there very thoughtfully. So thank you very much, and I'll see you all on June 1 and June 3rd.
Thank you. It was an exciting.
Can I express my thanks to the staff for all of the work they put in trying to, organize thousands of comments?
Yes.
Beyond belief. Thank you.
It is beyond belief. It was a lot for them to do. It was very complicated. I don't know how many times I had to ask for assistance in trying to get through the material. So yes, extremely grateful.
Quick question. You said that database is available on the website. Did I get that right?
The Power BI?
Yeah.
You can find the link in the staff report.
Okay. Thank you.
And I can also send it around to email it to this group.
Thank you. That would be real helpful.
I'll send that.
Great. Thanks for doing that.
Thank you.
Thank you all. Good evening.